So, dear guests, dear colleagues, dear friends of legal education, I'm happy to welcome you in Tallinn University and to our conference, Legal Education in Europe and Estonia in Light of the Digital Future. First, I would like to give word to the President of our Supreme Court, who cannot be here in person, but who has sent us a video postcard. Villu, Kõve, please.
Dear colleagues, dear friends, I'm pleased to open this international conference, Legal Education in Europe and Estonia in Light of the Digital Future. Unfortunately, I'm unable to attend it in person as I will be in a conference abroad at the same time. But I have spoken out on this matter repeatedly, but unfortunately, no significant changes have followed. I hope very much this conference will help to move further with that important topic. There are many questions to my mind we should deal with, and some of it will I remark here, and I hope you will discuss them. The first one, the most important question is, what will be the lawyer of the future? What will he look like? How many of them we need? And with what qualification do they need? Do we need a creator and developer of law, or machine developer and teacher, creator of algorithms, or just operator? Should we distinguish between a classical lawyer and others? The second important topic is how we should teach the lawyers. Mass education or more personal education. Bologna system or integrated law study program. Should law be taught separately or as a part of the social sciences? Do we need full-time study or more part-time study while students are working? Face-to-face learning or distance learning? More classical classroom-based or more independent work? Third one is, do we need state requirements for legal education? Or we have to stay to academic freedom? Does competition in legal education promote or hinder the fields of the development? How to compare different degrees? Do we need one unified lawyer's exam by state? And teaching the law, is it as a national discipline, or do we need more the international courses? What are the expectations for professor and other teachers, and what is offered to them? How to arrange new talents who have many other challenges? Do we need full-time work for the teachers or those who are working time alongside other jobs? Do we need local or more foreign teachers? And what is the significant use of the AI in the teaching processes? Will AI itself change the content of legal education? Generate learning materials, do homework? Do we have to tolerate or prohibit it? And last but not least, who should fund legal education and how? And is the existing funding being used optimally? Should there be a fee-based component? And if so, what proportion should be covered by state funding? They are all very important questions, and I will hope you will discuss them, several at least of these topics, and I look forward to hear your thoughts and suggestions. Fruitful days to you.
I hope this will not be a burden for us. I am happy to give floor to the director of the Institute of, it's Sogolas, is our acronym for that. She is actually today last day in her office. Tomorrow she will be a member of rectorate. Tiina Pajuste, my dear colleague, please.
Good morning, everyone. It's my pleasure to welcome you both as a legal scholar myself and as a representative of the university. So thank you all for coming and contributing to these discussions on the future of legal education. And thank you very much to Professor Madis Ernits for organizing this high-level event. There are two main reasons why this conference and these discussions are very important to us at Tallinn University. The first is that there are very many ongoing debates in Estonian society about the quality of legal education and should law be taught only in one university. There's many other questions that were posed in the video postcard to us before as well. So hopefully we have time to discuss these issues. So one of the mainstream views in Estonia is that we don't have, in a country as small as Estonia, enough resources to teach one subject matter in more than one institution. I strongly disagree with this position because I believe in the driving force of competition. I think that students need to be able to choose where to study. I also believe that staff, academics, should be able to choose where to teach and do research. So we need to have more than one choice. So if students and staff are forced into one university, then there is no driving force for innovation. There is no need for continually to improve study programs. There is no need to improve working or studying conditions as there is no better alternative available. And of course, the second reason why this conference and the discussions are important is to contemplate the ways to adapt to the era of AI. This means adapting our teaching and learning methods. We need to make sure that the students are aware of both the problematic and beneficial aspects of using AI and knowing what the acceptable boundaries are. So AI should be used as a tool to develop independent thinking, not to replace it. The future with AI in it also involves finding ways to deal with the problem of people seeking legal advice from AI. This means that both courts and government officials are on the path to being flooded by AI-written complaints, often of dubious quality. Yet there is an obligation to process all these complaints. The system is burdened, but there is no guarantee that the person's rights will be better protected. There are many challenges ahead, but there are also many new opportunities to make systems more efficient, to delegate mundane tasks, and to free up time for meaningful engagement. So I hope that these 2 days of discussions focus on the ways forward, relying on our shared desire for the best quality legal education that does adapt to the world around us. So thank you, everyone. Welcome, and let's have amazing discussions in the 2 days ahead.
So once again, welcome from my part. Tallinn is far away from Central Europe, and that's why I am glad that you have found a way here, despite of the fuel crisis, etc. We have numerous crises in the present world. Every lawyer is, in a sense, a specialist in legal education and has an opinion about it. Without successfully completing a law degree, no one could call themselves a lawyer. Thus, legal education is something we all had to go through in order to qualify as lawyers. And yet, we continue to research, analyze, and debate as a distinct field of scholarship. In other fields of study, there is, for instance, the didactics of mathematics or history, the pedagogy of physics, chemistry, or biology, and applied linguistics. The German term Fachdidaktik is used to capture them. But I think the legal discipline of legal education goes further than Fachdidaktik. When dealing with legal education, we do not only analyze how law is best taught and what should be taught, we also have to ask what law is. The discipline of legal education goes closer to the core of legal science itself than Fachdidaktik. We can discuss about that. Dealing with legal education is not a new phenomenon. For instance, Christian Thomasius dealt with legal education and jurisprudence in the late 17th century. He wrote, for instance, a wise lawyer should first and foremost concern himself with the first principles of knowledge and put his thoughts in order. I think this statement is still valid. Or, a wise lawyer must not neglect to use syllogisms in his writings and statements. I think this statement is valid too. And the third example, this is my favorite. One must first be quite clever and wise before one can become a poet and orator. In 2021, Estonian Supreme Court described the status quo of Estonian legal education. The general level of legal awareness and basic knowledge of the law among the public is low, which hinders their ability to function effectively in society. The poor quality of knowledge among legal advisors and other legal professionals prevents people from exercising their rights and increases their alienation from the state. The lack of a new generation of top-level legal scholars and senior government officials may begin to hinder the functioning of the state. The quality of legal education is inconsistent and low. The legal knowledge of those who have received such education tends to be poor and unstructured and does not meet the changing needs of society. There are no clear national requirements for law school curricula. The 3+2 program does not ensure that law school graduates meet the required standards. The administration of legal professional examinations is fragmented and geared toward excessive specialization, and some of the qualification requirements are too low. The Supreme Court also explained, trust, which is essential for economic development and the protection of the most vulnerable members of society, is founded on the rule of law. A lack of legal knowledge leads to poor quality laws, administrative orders and court decisions, including a proliferation of laws, frequent amendments and overregulation. Harsh administrative measures that have not been properly considered from a legal perspective can, in some cases, stifle economic activity. On the other hand, excessive leniency can lead to corruption, money laundering, destruction of the natural environment, and decline in technical safety standards, and so on. Legal advice that is uninformed and out of touch with reality poses a serious threat to freedom of enterprise and investment. The state itself must also defend its legal positions both within the European Union and globally as a contractual partner and as a member of international organizations and networks. It is impossible, for example, to hold the presidency of the UN Security Council or the Council of the European Union without understanding the legal mechanisms of these institutions. Lack of expertise in the implementation of EU law can lead to direct and significant economic costs in the form of fines, recovery of subsidies, and compensation for damages. More indirectly, it can result in missing out on benefits due to missed opportunities. The Supreme Court followed, in the end, and proposed following measures particularly. In academic legal education, the 3+2 teaching system should be abandoned in favor of a 5-year integrated undergraduate program. State-level substantive framework requirements for the academic law curriculum should be established. The criteria for accrediting law programs should be tightened with a greater focus on content of the subjects taught and the quality of instruction, while placing greater emphasis on Estonia's needs. In addition to the Estonian Higher Education and Vocational Education Quality Agency, the Ministry of Justice should be involved or assigned certain tasks to better oversee the quality of legal education. But the Supreme Court also suggested the state should fund the training of lawyers with advanced academic qualifications exclusively at a single university, preferably at University of Tartu. Academic legal education, which is state-commissioned and involves clear obligations, should remain free of charge for students. This could also be interpreted to mean that the law department at Tallinn University is redundant and should be closed down. So, what is our ambition in the coming days? Bearing in mind the Supreme Court's findings and recommendations, we seek to be a part of the solution. The world is changing at an ever faster pace. For a relatively long time, the legal education had quite clear identity. We trained lawyers, and society did not seriously question their necessity or role. We taught them how to understand cases, interpret and apply statutes, construct arguments, and, if all went well, to think like lawyers. It was not perfect and varied, certainly from country to country, but it was at least more or less coherent. The role of lawyers in society was widely accepted. Lawyers were recognized as the guardians of the rule of law, ensuring that society functions predictably, fairly, and within the boundaries of rules established by the democratically elected parliament. Lawyers serve as a primary shield against the arbitrary use of power. They ensure that every person, regardless of their status, has access to a fair trial and that their fundamental human rights are respected by the state and other powerful entities. A large part of legal work is, so to say, preventative medicine. By drafting clear contracts and providing sound advice, lawyers help people and businesses avoid disputes before they start. When conflicts do arise, they act as mediators and negotiators to find peaceful, structured solutions. Modern society relies on a complex web of laws to function. Lawyers interpret the legal provisions so that citizens and companies know their obligations. This legal certainty is what allows markets to thrive, and it ensures that agreements will be enforced and property protected. Lawyers often lead the charge of reform. Through constitutional review and policy advocacy, they challenge outdated or unjust laws. Many landmark social shifts have begun as legal cases brought forward by dedicated attorneys. Lawyers have a duty to represent their clients' interests diligently, but they also have an overarching duty to the court and the truth. They are supposed to be the moral compass. By upholding professional ethics, they maintain public trust in the justice system. In short, lawyers are the social glue that keeps society together, interactions civilized, and ensures that might does not make right. All this is under pressure today, internationally and in some countries nationally as well. I am not saying that lawyers have lost their importance, but they have nonetheless been sidelined from many important decisions in which they should, in fact, be involved. The importance of lawyers in society appears to have declined. This development casts a shadow over legal education. Today, if you pose the question what legal education should do, the answers are more diverse. Excuse me. We are told that we should prepare students for the legal profession, but also for jobs that do not yet exist. We should preserve tradition, but also innovate. We should be academically rigorous, but also practice-oriented. And of course, we should integrate digital technologies without quite knowing what that actually means. Proceeding from this, we see that for a smaller country like Estonia, poor legal education can become an existential problem. In such system, every institutional decision matters. Every program, every faculty, every reform has visible consequences. This makes discussions about legal education less abstract and at times more uncomfortable. And this is precisely why this conference matters. As lawyers, we are trained to look for answers. We are trained to decide, and for that we seek for clarity and certainty. We are certainly not going to get answers to all questions over the coming days, and we are certainly not going to produce a final statement to the future of legal education. That would be unrealistic and probably not very interesting either, because we do not want to avoid more difficult questions. So I would encourage you to be open, to be critical, and within reasonable limits, of course, to be provocative. Academic politeness is, of course, a virtue, but it should not prevent us from saying things that are actually worth saying. We are ready to discuss our problems and questions openly, and we are willing to learn from you. Before we engage, I would like to thank my esteemed colleague Indrek Grauberg, who has been involved in the planning of this conference from the very beginning. I would like to pay tribute to my dear colleague Urmas Volens, who was also there at the inception of this conference and was scheduled to speak at it, but who sadly passed away unexpectedly. I would also like to thank one of my teachers and current colleague at the faculty, Peeter Järvelaid, whose writings on legal education have sparked my interest in the subject and inspired, I think, many of us. Thank you. Distinguished guests, dear colleagues, dear friends of legal education, thank you for coming, and I wish you an engaging conference. Now, I have first two technical announcements to make. First, with one exception, our conference will be filmed, so we can make it available to the public at a later date. So please bear this in mind. If you pose questions, you will be filmed. Secondly, we have the option of using Slido to ask questions. There will be an opportunity to ask a question via the microphone as well. I cannot guarantee that all the questions will get an answer, but you can choose either to pose a question via Slido or via microphone. And now I would like to present the first speaker of the first panel, Professor Martin Loughlin from London School of Economics and Political Science. He is Professorial Research Fellow and Professor Emeritus. He is a leading scholar in public law and legal theory, known for his influential work on constitutionalism, the foundations of public law, and the nature of the state. Mr. Loughlin, the floor is yours.
Thank you very much indeed, Madis. Thank you so much for the kind invitation to address this conference, especially since it's a topic on which I claim absolutely no expertise. Nevertheless, recent technological developments have caused me, like many others, to reflect on this difficult question of what legal education is seeking to achieve, and there's no doubt that it's complicated. So, in the time available, I only want to share with you some rather basic points in order to present a provocative argument. Provocative, as Madis says, within reasonable grounds. And the provocative argument is that AI has nothing to contribute to legal education, properly so called. It's not nearly as controversial as it sounds, so bear with me. So as to get started, let me begin with a simple claim. That is, that law is an attempt to subject human conduct to the governance of rules. If we look at law that way, it would appear that it's a social practice that comes into existence with or at least is formalized with the invention of writing. We then trace it back to, say, the Code of Hammurabi, the foundational Babylonian legal text written about 1800 BCE, and we can see that subsequently there have been various landmark moments in Western legal history, including the work of the lawgivers of ancient Greece, the 12 tables providing the basis of Roman law, or later Justinian's Digest, which provides a Roman law foundation for many of the legal systems of medieval Europe. From that sort of survey, we discern that the study of law involves the acquisition of knowledge of the rules promulgated by some established political authority and through which society is regulated. That knowledge comes to be invested in a literate clerisy, epitomized, say, by the scholastics of the High Middle Ages. And through this evolution and independent social practice of law, a practice of law distinct from theology, from ethics, from politics, came to be formed. This is a distinctive feature of Western civilization, and it's manifest in the emergence of these discrete practices of legislating and adjudicating. Well, if the first innovation comes from the invention of writing, next comes from a second revolution, the invention of printing. The mechanization of printing through the invention of the printing press in the 15th century permits law books to be produced and distributed on a larger scale. And it's this era that sees the birth of legal education, modern legal education, I should say. We recognize it in the emergence of the great centers of European scholarship in Italy, France, and the German lands. Some countries, such as England, were very late in the game. The first comprehensive text of English law was Blackstone's Commentaries, published in 1765, and legal education in the English universities only gets going in the late 19th century. But in any case, it's only in the modern era that we see the rise of the standard format of legal education, that is, the study of law in universities, followed by more technical professional instruction in professional law programs. These modern societies are marked by the proliferation of rules. Furthermore, with their growing complexity, it soon becomes clear that in these societies, legislatures are no longer the predominant rule makers. A variety of governmental agencies now generate a myriad of rules of law. And these laws no longer simply prescribe general rules of conduct. A multiplicity of laws is now drafted constantly for special groups: engineers, farmers, bankers, chemists, corporate managers, and such like. Today, there are so many laws, so many rules regulating various aspects of social conduct that it is irrational for any one person to attempt to acquire a comprehensive knowledge of them. So in these conditions, what does legal education become? It's at this point that scientists begin to suggest that mechanical techniques can perform a useful role in assisting with the task of acquiring legal knowledge. For as long as I can remember, and that's quite a while these days, for as long as I can remember, computer scientists have been seeking to do just that. In highly developed rule-based systems, such as tax law, they have sought to devise computer programs that would yield answers to complex tax issues. Their work, however, is best understood as an attempt to deliver on the promise of what a century ago was dismissively called slot machine jurisprudence. The legal system, it was argued, should be seen as some sort of insensate machine. All one need to do is plug in the facts, and the machine, as the repository of the rules, would produce a decision to the question at issue. And it's that sort of model that the early computer scientists had in mind when trying to produce these answers. Once we accept this imagery, the world of formal legal rationality that Max Weber raised to the status of an ideal type comes into play. This is a world in which we assume that legal rules exist as logically clear, internally consistent, and providing a gapless scheme of propositions so that all conceivable fact situations are capable of being logically subsumed under those rules. It has, of course, never been so simple. Law is not just the attempt to subject human conduct to the governance of rules. It is an attempt to subject human conduct to the governance of rules through language. And there are distinct limits to the ability of language to grasp the complexity of the world. The English legal philosopher H.L.A. Hart argued that words, and indeed sentences, might have a core of settled meaning, but surrounding them there's always what he calls a penumbra of doubt. And this gives rise to significant methodological challenges of interpretation. And more than this, the attempt to subject human conduct to the governance of rules is an attempt to regulate future conduct. And since the lawmaker, being human, will have a limited capacity to foresee the variety of factual situations which may arise in the future and therefore potentially fall within the ambit of the rule, there's a similar degree of uncertainty and ambiguity on whether or not a particular rule applies in any novel fact situation that might arise. And that too enhances the problem of interpretation. Once this is appreciated, law must be seen to require the employment of intricate interpretive methods. These interpretive difficulties should not be underestimated, and they are further exacerbated by virtue of the fact that with growing social complexity, the challenge of achieving social integration through rules means that contemporary legal systems are obliged to utilize sets of norms that operate at a much higher level of abstraction than rules. These more abstract items, standards, are commonly called principles. That is, they're given a normative orientation and called principles. That a person should not be permitted to profit from their own wrong is one such principle. But there are also entire fields of law that function through these more abstract standards. In English law, civil liability for the tort of negligence mainly operates through these type of general standards. Is there a duty of care? What is the standard of care? How remote is the damage that caused from that duty? Similarly, in European human rights law, the basic rights to be protected are formulated at very high levels of abstraction. Rights to freedom of speech, freedom of expression, freedom of association, the right to family life, and so on. And they're mostly qualified by such restrictions as are prescribed by law and are necessary in a democratic society. As my former constitutional law teacher once said, this formulation sounds like the statement of a political conflict pretending to be a resolution of it. All this suggests that legal reasoning is a much more intricate undertaking than the application of rules to a given fact situation. The rule-based Weberian model implies that the process is one of deductive reasoning, whereas so much of legal reasoning is analogical. Is case A similar to case B? This may seem fairly trite, but it does indicate why early attempts to devise computer models that could generate these legal decisions didn't get very far. Analogical reasoning is employed by lawyers precisely because of a lack of agreement about the meaning of the enacted rules. We reason analogically and focus on particulars because then it seems unnecessary to have to agree about the ultimate meaning of the rule. Now, all this is by way of historical background and general context. The issue we face today causes us to recognize that those earlier efforts at mechanization were products of a particular perception of law. But it's also the case that computer technology was then in its infancy. We are now confronted with a third revolution, which many argue will be just as powerful as the writing and printing revolutions, and this is the digital revolution. Large language models trained on vast internet-based data sources can not only search legal text on a superhuman scale and speed, but also extract that knowledge to deliver clearly organized legal arguments and offer answers to disputed legal questions. This technological revolution will undoubtedly have a major impact on legal research and legal writing. Students will need to be trained on their use. And it will certainly affect the university's examining function. My own institution, for example, has now entirely withdrawn from the use of assessed essay work as summative assessment and retired to the old traditional way of evaluating by unseen formal written examinations. Why? Because of a lack of confidence in devising robust procedures to determine whether the essays are actually the student's own work. But all this, I want to suggest, is tangential to the venture of being educated to understand and appreciate the humane practice of law. Legal education is not an induction into the acquisition of knowledge of rules, even though acquisition of knowledge of many of the rules is undoubtedly a relevant element in that process. So what is it? Well, it might be said that it's the process by which we acquire an understanding of how law thinks with respect to a particular social field. Legal education is, first of all, an education in language acquisition. Language acquisition in the context of the immersion into the various subsystems of society. Let me give an illustration of the former point. When I was taught the law of contract, well, a good few years ago now, I have to say, but when I was taught the law of contract, we were not prescribed a textbook. All we were given each week was a list of cases to read, digest, analyze, and come along to discuss. We were not told this, but it seems that it was assumed that we would acquire a knowledge of contract law by being immersed into the interpretive difficulties that judges encounter in finding facts, in identifying a similar previously determined case, in deriving a principle from this, in locating exceptions, in distinguishing other possible precedents, and in reaching judgments. It was assumed that we would get to grips with the law of contract by being immersed in the literature. And being so immersed, we would acquire a knowledge of the vocabulary of the subject and eventually the grammar of the subject. We would develop a certain literacy about what it is to think in legal terms about these social problems. Now, of course, as students with limited time and energy and many distractions, we used cribs. The most important crib in my ancient days was a case headnote. And this was instead of having to read the really long, tedious, rambling judgments, and then the other judgments that descended with the leading judgment, the headnote at the beginning of the case, as reported, would provide a summary of the essential facts, the main legal rules, and the main findings of the court. That gave us easier access to knowledge and gave us access to the rudiments of reasoning. But we acquired, if we relied entirely on the headnote, a limited understanding. We would not be very well educated in the law. And the fact of the matter is that the headnote is a rudimentary technology. It's a device that gives us ready access to basic facts and essential reasons for the decision. And if students were to rely entirely on headnotes, or indeed the distillation of those headnotes that we find in textbooks, they would not be getting much of an education. And this, a fortiori, is the case with respect to the use of AI. The point I'm trying to get to is that, properly understood, legal reasoning does not entail the application of general rules to diverse facts. Rather, the legal exercise is altogether much more complicated. One way of expressing this is to say that the rules change in the process of seeking to apply them to any particular set of facts. The change occurs because the meaning of the rule depends on the determination of which facts will be considered as similar to those found to exist when the rule was first articulated. And once this is realized, that in such a process, facts are just as much socially constructed as are the rules to which they relate, then the notion that somehow the task is to match the facts with the norms is revealed as being wrong. The rendering of fact, just as much as the identification of the norm, is an exercise in representation. It's an exercise in symbolic representation. There are no hard facts in the world of law. The facts are made in the process of litigating. And the rules are adjusted in that process too. Now, in his classic essay on legal reasoning, the American scholar Edward Levy argues that the real challenge for the law is to determine when it will be just to treat different cases as though they were the same. There is, he argues, a process of reasoning involved in this exercise, but it's one in which the legal classification subtly changes as the classification is made. Similarly, the rules change as they are applied. Put another way, the classifications used in the legal process must be left ambiguous in order to permit the infusion of new ideas, in order to keep the law up to date and responsive to social development. This, Levy explains, is the way that law does the vital work of maintaining its responsiveness to the prevailing ideas in society. Those who participate in litigation are also participating in law making. Judges who reach a judgment are shaping the conduct and opinions of the community because judges are part of the ruling organization and their judgments reflect the power structure, the changing power structure of that community. And I think this is what legal education aims to teach. That the legal representation of fact is normative, just as the legal presentation of the norm is, in a sense, factual. In this way, legal institutions operate by negotiating between a language of imagination and one of decision. And in the process, they develop a determinative sense of justice. But how? To this point, I've been addressing a relatively simple case of evolution in the context of judge-made private law. I think it's even more complicated in my own field, the public law context. Not just because of the overarching but skeletal statutory frameworks with which we often deal, but also because of the complexity of the social fields which these public law questions are seeking to regulate. So the exercise of legal education, of the immersion in these subjects, is as much an education in trying to understand the complexities of financial law or competition, competitive markets, or land development questions. So it's not just an education in the rules, it's an education in the subsystem of society that the rules are seeking to regulate. All of which leads us to claim that law cannot be assumed to be an autonomous system of rules independent of the social, political, and cultural matrix that shapes its character as institutional order. Law expresses a culturally specific way of being. It is a complex of characterizations and imaginings, stories about events cast in the imagery of principles. Law is local knowledge, not placeless principle. And it's from this legal point of view, law can be seen as a constitutive feature of social life, not just a reflection of it. So, legal interpretation involves an interminable interplay between the relative authority of rules, the text, the previous similar case, the precedents, the analogies, and the normative standards, the principles, the abstract standards cast in normative terms. Now, the point, this is my ultimate point, I think. The point is that jurists have developed rigorous accounts of the canons of textual interpretation. Jurists have developed rigorous accounts of reasoning analogically with precedents. Jurists have developed rigorous accounts of the methods of balancing, of reaching the optimization requirements of balancing of principles. Each of these methods are taught as elements of legal education. And each of these methods can be utilized in large language models to discern answers to the meaning of a particular factual dispute. But the point is that AI is unable to produce authoritative methods of weighing the relative importance of each of these factors. Whether we rely on the text or the precedent to reinterpret the text or the principle to overturn the precedent. AI cannot do that because jurists themselves have been unable to find some meta-level method by which we assess the relative importance of the text or the precedent or the principle. And that's not surprising because the emphasis on each of these three elements of legal reasoning express subtly different conceptions of what law is all about. These conflicts cannot be determined by legal method. They require an exercise of practical knowledge, or, in the sphere in which I work, political judgment. If we think that AI can replace this exercise in judgment, then we're handing over responsibility not for legal application, but for lawmaking to machines. Machine modeling works on finding correlations between many variables, and even if it works well in predictive situations where pattern recognition can be employed effectively, it's surely dangerous to think that we can replace political judgment, in that broad sense of political judgment, with what is effectively statistical assessment. LLMs that can extract patterns from vast bodies of data, but they surely bear out Max Weber's claim that increased rationalization of the world does not necessarily lead to an increased understanding of the conditions under which we are living. And the exercise of legal education is an exercise in trying to understand the conditions under which we are living. And that's all I have to say about the subject, so thank you.
No. Thank you very much, Professor Loughlin. We are proceeding to our next speaker. Our second speaker is Professor Andrej Lang from the Chemnitz University of Technology in Germany. He is specializing in public economic law, and his research examines German, European, and international public law from a theory-driven, comparative, and interdisciplinary perspective. So, Mr. Lang, the floor is yours.
Thank you. Professor Ernits, Professor Loughlin, distinguished colleagues, ladies and gentlemen. I would like to thank the organizers warmly for the invitation to speak at this conference on legal education. Let me begin with a question that sounds simple, but is in fact anything but. What is legal education for? The question is not new, but it is freshly urgent. Legal systems across Europe are simultaneously Europeanizing, internationalizing, and digitalizing. And yet our legal education in Germany and elsewhere is, in important respects, based on a paradigm developed a century ago. Before we discuss what legal education should become, we have to be clear about what it currently is and what work it is supposed to do for the legal system and for society. I will approach this question comparatively through the lens of my own lived experience. I'm a German lawyer who completed both state exams, but I also spent a substantial portion of my career in the US. I did an LLM, passed the bar exam, worked as a litigation associate, and conducted research at US law schools. Hence, I will compare the two models of legal education that I have experienced, the German model and the American model. The comparison is illuminating because the two models were built around fundamentally different answers to the question I just posed. My core argument runs as follows. First, both models capture something essential about the role of legal education. The German model emphasizes systematic and doctrinal depth. The American model emphasizes interdisciplinary breadth and intellectual openness. Second, Neither model in isolation is fully adequate to the demands placed on lawyers in the 21st century. Third, three cornerstones must therefore become essential in European legal education going forward: internationalization, interdisciplinarity, and civic responsibility. Fourth and finally, the rise of generative AI and large language models does not change this diagnosis, it sharpens it. I will lay out my argument in 4 steps. First, I sketch the German and the US model. Second, I assess their respective strengths and shortcomings. Third, I defend my thesis on the cornerstones of legal education in the 21st century. Fourth, I conclude with some remarks on the implications of AI. Let us begin with the German model. Its essential features are condensed in paragraph 5 of the German Judiciary Act, das Deutsche Richtergesetz. The aim of legal education in Germany is Befähigung zum Richteramt, the qualification for judicial office. The path to that qualification runs through the German Staatsexamen system, which is globally near singular. 2 state exams are required. The first follows university study. The second follows a 2-year practical training period, the Referendariat. Crucially, the first state exam is not a university, but a state examination, conducted by an examination board outside the university, a department within the ministries of justice on the state level. Yet, legal education in Germany is already designed to prepare law students for the state examination, the terms of which are largely set by legal practitioners. 2 features follow from this basic structure. First, German legal education produces the Einheitsjurist, the unified jurist, a generalized trained to perform every role in the legal system. In terms of historical genealogy, this model reaches all the way back to the Prussian civil service state. Second, the curriculum is shaped indirectly but powerfully by the requirements of the state examination. This produces a tight focus on black letter law and on doctrinal legal reasoning. The doctrinal and systematic mastery of positive law is simultaneously an academic ideal and a pedagogical program, one owed to the student in order to prepare her for the state examination. The American model could hardly be more different. The American JD is a graduate degree. Students must first complete an undergraduate degree in another subject, philosophy, economics, history, before they can enter law school. Law school is structured as a professional school sitting on top of a different academic foundation. The pedagogy is dominated by the case method introduced by Christopher Langdell, the dean of Harvard Law School in the late 19th century. Langdell's original ambition was scientific. He believed law was a science, legal science, to be studied like the natural sciences, extracting insight into the overarching legal principles of the system through the careful analysis of judicial decisions. The idea of legal science collapsed under the realist critique in the early 20th century. Paradoxically, Langdell's pedagogy survived and indeed flourished even after the scientific ideal it was meant to serve was abandoned. Today, the case method continues to define the daily life of nearly every American law school, although in service of a radically different intellectual vision. That intellectual vision is interdisciplinary. Ever since the loss of faith in doctrinal legal science, American legal scholarship has come to mean very largely the study of law through the lens of another discipline: economics, history, philosophy, political science, sociology. This is supported by the institutional structure. Students arrive with a college degree in another field. Faculty increasingly hold PhDs in those other fields. The curriculum after the first year is almost entirely elective. These are very different answers to the question of what legal education is for. The German model says legal education is the systematic transmission of doctrinal mastery, validated by a centralized state examination in service of legal practice. The American model says legal education is the interdisciplinary study of how law actually operates. Detachment from practice is considered an intellectual virtue, not a vice. Let me now turn to normative assessments. The German model has real strength. Andreas Voskuhle, the former president of the German Federal Constitutional Court, has put the case as follows. The Staatsexamen, he argues, sustains a uniformly high level of quality across the country. The intensive year-long preparation fosters a broad and systematic understanding of the doctrinal interrelations of the legal system. Approximately 10 to 20% of German law graduates achieve the coveted vollbefriedigend mark or better, and they need fear no comparison with the top graduates of any other system. And, this is important, the path to the elite is not gated by the ability to pay for an Ivy League law school. It stands open to anyone willing to confront the rigor of the Staatsexamen. This is an achievement of the German social state worth defending. But the German model also has serious blind spots. The Staatsexamen, by its very nature, exerts a massive gravitational pull on the curriculum. Subjects that fall outside its scope, the Grundlagenfächer, legal history, legal philosophy, comparative law, sociology of law, are systematically devalued. The pedagogical culture of doctrinal legal science is precisely what stands in the way of opening the curriculum to broader, comparative, international, and interdisciplinary perspectives. The American model has its own complementary strength. The interdisciplinary structure produces graduates accustomed to crossing disciplinary boundaries, accustomed to encountering law not as a closed system, but as an object of study. It nourishes critical reflection and holistic analysis. And, as Simon Chesterman, the former dean of National University of Singapore Law School, observes, this intellectual openness, characteristic for US top law schools, has become a global model increasingly emulated in Asia, in Latin America, and indeed within Europe itself. But the American model also has serious blind spots. It is in many ways an elite phenomenon, and it tends to disregard the genuine distinctiveness of legal analysis. So we have two models, each with structural strength, the other lacks, and each with blind spots, the other covers. This is not, however, an argument for some easy synthesis, picking the best of both worlds. Such an exercise tends to underestimate how deeply each feature is embedded in the broader legal culture from which it grew. The interesting comparative question is therefore not which features to import, it is which functions each system performs well and which functions our changing world now demands of legal education. This brings me to my central thesis. The professional ideal of the lawyer has changed fundamentally in the past century. From the positivist judge who merely subsumes facts under national law, to the lawyer as a legal advisor, architect of legal arrangements, and creator of law capable of navigating international contexts. In place of a nationally introverted exegesis of statutes and case law, emerges a problem-oriented exchange of legal arguments and approaches to solutions. Legal education, notoriously resistant to change, has not fully adapted to change demands. The aim of legal education can no longer be to demand even a broader and more comprehensive knowledge of positive law. By contrast, I want to argue that three demands must become cornerstones of legal education in Europe going forward. The first is internationalization, the second is interdisciplinarity, the third is civic responsibility. Let me begin with internationalization. Why must legal education internationalize? The first answer is empirical. Law and society no longer operate within neatly bounded territorial spaces. They are densely interwoven across borders. The growth of trade and legal services, driven by the global society, has pulled an even larger share of lawyers into cross-border work. This is no longer the preserve of small elite working at multinational firms representing multinational clients. Solo practitioners and small firms now routinely encounter questions of foreign law, drafting contracts with foreign suppliers, complaints against foreign manufacturers, custody and adoption matters touching foreign jurisdictions. The conclusion is, if domestic practice itself is increasingly globalizing, education must follow. And here, the demand is not formal, but substantive. It is, as Voskuhle put it, about orienting legal thought, legal action, and legal education in substance towards Europe and the world. Comparative and international perspectives must be integrated across a wide range of subjects, not parked at the margins of the curriculum as an optional specialization. Chesterman predicts that this intellectual shift towards globalization and away from a purely local approach to legal education will continue and ultimately become irresistible despite nationalist populist movements in the United States and Europe. The case for this shift is strong in any legal system, but in Europe it is overwhelming. European lawyers operate by definition within the integrated Verbund of overlapping legal orders, national, EU, ECHR, international. A predominantly nationally oriented legal education risks abandoning a generation of young lawyers, training them in effect for Europe and a world that no longer exists. The second cornerstone is interdisciplinarity. Here too, the comparative perspective is illuminating. The American system has interdisciplinarity built into its institutional architecture. The German system, by contrast, structurally discourages it. And yet, the demand for interdisciplinary competence is not an American demand, it is a demand of contemporary legal practice in any developed legal system. Lawyers must be capable of interdisciplinary work. This does not mean mastering every other discipline. It means lawyers must be curious, must be willing to be irritated and inspired by other disciplines, must be able to enter into a conversation with economists, sociologists, historians, philosophers, and today more than ever, computer scientists. The legal questions of our time, climate change, democratic resilience, migration, digital governance, and AI regulation cannot be answered solely from within a closed system of doctrinal categories. They demand lawyers who understand legal thought and doctrine in one direction and hold an interdisciplinary conversation in the other. An education that confines itself to the doctrinal application of national positive law does not produce such lawyers. An education that drifts into pure interdisciplinarity, untethered from the specific craft of legal reasoning, does not produce them either. The challenge is to combine both. Third, a lawyer, as we wish her to be, is not a technocrat. The profession of law is fundamental to the flourishing of democracy. Lawyers who exercise and control power carry decisive responsibility for democracy, for the rule of law, and for human rights. They are bearers and mediators of the values that ground a liberal constitutional order. Law faculties and law schools are where this civic role is or should be formed. It is the one experience virtually every lawyer shares. The moment when the profession's defining values are placed on display and when future lawyers begin to assume and to critically examine the identities they will carry forward. An institutional consequence follows. University legal education, as Vosskole insists, must not be reduced to a mere professional qualification. It must remain bound to the freedom of scientific inquiry, to the principle of first the theory, then the practice. For nowhere is practice learned better than in practice itself. By contrast, the necessary foundation that turns a mere applier of the law into a civically responsible lawyer can only be provided by a theoretically and foundationally oriented university education. Legal education in this sense is not just about producing competent lawyers, it is about sustaining the liberal constitutional order they serve, especially at a time of democratic backsliding when the very future of liberal democracy itself is at stake. Let me now turn in the final part of my talk to the question that hangs over every conference on legal education today. What does generative AI change? I will try to be concise. The factual situation is well known. Large language models can already pass the American bar exam. They review contracts at quality levels comparable to junior associates, at a fraction of the cost and a fraction of the time. The market for legal services is being reshaped in real time. Given the rapid pace of technological development, it is to be expected that the capabilities of AI systems will continue to improve. In other words, the genie is out of the bottle. AI is here to stay, especially in the legal field, likely leading to a transformation of training and employment structures within the legal professions. It is tempting in this situation to draw one of two conclusions. The first conclusion is dismissive. The classical methods of legal training have proven themselves and need not change. The second conclusion is alarmist. Legal education must be fundamentally reinvented. I think both conclusions are wrong. Legal education has already undergone numerous paradigm shifts, thereby continually renewing itself and it is well equipped to defend its relevancy even against the backdrop of AI. But I do believe that the rise of AI sharpens the diagnosis about a more integrated model of legal education I have just offered. First, AI strengthens the case for teaching students to think like a lawyer. Critical thinking, analytical rigor, sound judgment, civic responsibility, problem awareness, and the capacity to solve a case from the ground up. These are precisely the capacities that allow a lawyer to detect the hallucinations of a language model and to take responsibility for a legal decision. Second, AI strengthens the case for interdisciplinarity. Anthropic President Daniela Amodei recently predicted that advanced AI systems will increase rather than diminish the importance of interdisciplinary understandings. In the future, lawyers will require an even broader skill set beyond the legal method. They need a basic technical understanding of how AI actually works, its modes of operation, its strength, its weaknesses. If code is law, as Harvard professor Lawrence Lessig claims, then lawyers need basic competence in coding and statistics, not to become computer scientists, but to be able to enter the necessary conversations. They must understand the technical, ethical, political, and economic underpinnings of AI technology. Third, AI strengthens the case for internationalization and, in particular, Europeanization in legal education. The regulatory framework for AI is today quintessentially European. The AI Act, the General Data Protection Regulation, the Digital Services Act, the Digital Markets Act, these instruments shape the practice of every European lawyer working on the digital interface. The teaching of the national law, of the law of digitalization, of AI regulation at the EU level and its effects on national law ought to become a necessary component of the curriculum. One last observation. The unique selling point of a good lawyer is critical thinking. Critical thinking towards the law itself and critical thinking towards the AI tools that purport to apply the law. AI, used well, is an instrument for expanding horizons and fulfilling routine tasks much more efficiently. AI, used badly, is an instrument for outsourcing the very faculty of legal judgment. Which of these futures we create depends in large part on the legal education we provide. Let me conclude. I have argued that the role of legal education is and must remain dual. It must produce lawyers capable of mastering the legal craft, its particular way of thinking, its distinctive stance toward the world, as the German system has always emphasized. And it must produce lawyers capable of understanding the law as a social, political, technological, and transnational phenomenon, with the interdisciplinary curiosity the American system has institutionally favored. European lawyers on whom the workings of democracy and the rule of law in Europe depends require both. Thank you for your attention. I look forward to your questions.
First of all, thank you very much to both of you. And I will check whether we have questions in Slido. Not yet. No, it's wrong. Yes, why is this? Okay. I have a couple of questions actually one question first to both of you. Thank you. Martin, you said that this AI is completely useless in detecting the method it doesn't add very much new value to the legal work. Could it be that that AI is more capable with its almost unlimited skills to detect the method of methods? Is it possible?
Well, given my presentation, I'm obviously incompetent to answer that question. But I was being deliberately provocative when I say AI has nothing to contribute to legal education, because I was trying to understand in a very precise, narrow, technical sense what education in the law actually means. And I don't think AI, as I try to say, it's obviously a major factor in the education of students in legal research and legal method and legal writing and indeed legal reasoning, but it doesn't get to the heart of what an education in law is. I think ultimately law is, as I said, I'm just repeating myself, an exercise in prudential reasoning based on experience. But you would say that because I'm an English common lawyer who's trained in that sense. I mean, one of our great chief justices from the 17th century argued that law is not natural reason, it's artificial reasoning that requires long experience before that one can attain to the cognizance of it. And it's ultimately prudential judgment and political judgment. And one can't replicate that with machine models to this point. Whether it can in the future, God help us all if that's the case. Because that will actually be the end of law in the modern understanding of the discipline.
Indeed. You are free to comment, of course, but I would pose a question to you two first. You made 3 suggestions to improve legal education: comparativism and internationalism, interdisciplinarity and civic responsibility. No doubt, they all seem very reasonable. But in what relation to these 3 suggestions is the critical thinking? Is it a consequence of these 3? Or is it already there? Or is it something that we should actually try to improve and educate separately, develop separately?
Yeah, it's a good and fair question. I think I think they are very closely interrelated with each other, right? It's not, of course, you can teach legal theory without internationalization, without interdisciplinarity, and I mean, probably harder without civic responsibility and kind of like the broader moral and ethical implications of legal thinking. I think they are probably part legal theory, but I still think that, for example, let's take interdisciplinarity, right? When you you look beyond just a kind of the legal dimension of the case, you look at broader social ramifications that lead you to considerations of justice. You look at economic effects of technological ramifications of legal thought and the application of the law to specific cases. I think that is something that furthers critical thinking. Similarly, I think with internationalization or let's take comparative perspectives, right? Looking at other jurisdictions, looking at other layers of governance like the EU or international law. I think this is also to see how things are done differently in other legal orders is also something that leads you to reflect on your own legal order, on like taking something less self-granted. So I think they are very. I think it's not an indispensable feature of critical thinking, but I think it's clear it's closely interrelated and it furthers critical thinking.
Okay, thank you. Are there any questions from the audience? Lauri.
It's a bit complicated system. My name is Lauri Mälksoo. I'm from University of Tartu, also here in Estonia. So this AI, I'm somehow still very, very puzzled about what it will bring and kind of uncertain. Is Professor Lang, what you described, this AI being able to pass successfully the New York bar exam, isn't that in the end still bad news for the lawyers in the sense that, maybe we will be one of those professions that in several ways will go out of business? Would you address that? Will there be in the future less need for lawyers if AI can generate those complaints to state authorities and even lawsuits and who knows what else?
I think this is also an important question. So, as Professor Loughlin has argued, right? I think there is clearly kind of the craft of lawyering is also depends on moral reasoning, on political judgment. That's also part of it, and I think there large language models encounter limits. So if we look at judges on high courts, law professors, lawyers at partners at big law firms, I don't see large language model being able to emulate kind of this legal judgment. But what I do think is that AI provides a huge challenge for law students and young lawyers, right? Because I think it takes a long evolutionary process to become a good lawyer. It requires a long experience, right? And it kind of to reach the level of legal argument that large language models can achieve. I think it takes a long learning curve. I think a law student in the first or second year, I think if they need to solve a constitutional case, I think probably they'll get better answers from large language models than when they kind of start from the beginning. So, I think that's the real challenge, is to educate young lawyers to kind of still give them the training to reach the level of sophistication in legal craft, kind of that makes them better than large language models, right? And I think there we have a responsibility in legal education not to ignore large language models, but to integrate them into the curriculum to give students the tools to use large language models while without kind of losing their own ability of legal judgment, of critical thinking. So basically using large language models as a tool to become a better lawyer rather than replacing kind of the own capacity of legal thinking.
There is a question. Microphone.
Thank you very much. AI has no...
Could you please introduce yourself?
I'm Eugene from Tallinn. So AI has no fear. It doesn't take bribes, etc. So my question, what is the role of human bravery, courage in legal education?
I don't think of lawyers as particularly courageous professions. They serve their masters, and their masters are those who employ them to do their bidding. They're hired guns in the old American phrase. But no, I can't answer that question. I'm sure Andrej can address it better. But I have a question for Andrej, actually, because not just for him, for us. Really interesting presentation, and an illuminating presentation on how there's a necessity for us in legal education to, in response to these developments, to be internationalizing, moving to interdisciplinary perspective, enhancing notions of civic responsibility and such like. But I couldn't help but think that that is education for elite lawyers. The legal profession is not a singular phenomenon. There are many local lawyers who deal with local disputes. And in interdisciplinary work, international perspectives, not really part of their career world. So are we not simply talking about, it's the world I live in, the international elite world of the big multinational corporations that are increasingly dominating the legal profession. But I do wonder what that means, both for ordinary legal services, housing law, social security advice, servicing local citizens, because none of what we were discussing relates to that. And then there's a secondary issue, which is, what about a small jurisdiction like Estonia? There's always a tension between retaining your own domestic legal culture and having to respond to these great internationalizing developments. And if you internationalize too much, do you lose your local legal culture? Sorry, just observation. Designed to avoid answering your question about courage.
So now I'm confronted with one comment about my presentation and the question. Maybe I'll first say something to Martin, yeah. And then follow up on your question. So first, there's clearly the risk of a structural bias, like for someone. For a law professor who is part of the global elite, to basically transplant kind of the own worldview to legal education more generally, and kind of to local lawyers who kind of represent local clients. So I don't. There is this risk exists, and I don't want to talk it away. But but I still, so it's ultimately an empirical question. To what extent is kind of the local legal practice really influenced by Europeanization, internationalization, requires kind of more interdisciplinary perspectives? Kind of my sense is that these, I mean, of course, we still need to teach German law, Estonian law, British law to, they need to be part of the core curriculum. And it's not that, for example, McGill is kind of, the university in Canada is famous for this kind of a bachelor study of law that's called transnational law, right? Which kind of is epitomizes a kind of this move away from a local teaching to kind of just the transnational. And there's also the risk that something is lost. So it's, I don't argue for replacing entirely the teaching of national law, but I still think that my sense of the legal practice is genuinely that transnational European issues will regularly face. And so I think it needs to play a more prominent role in the curriculum today than it played a long time ago. And I think one kind of basic insight is that it's really the law curriculum has been very slow to change. Maybe I could imagine that universities like LSE are a bit more faster in changing, but in Germany, like the curriculum is very old and is centuries old. And I think there kind of more internationalization and interdisciplinarity is necessary. The second point, I think what's also an interesting question about a country like Estonia, it's like a small country, what's kind of the balance between preserving local culture, local values, and the kind of the need to adapt to international influences and pressures. I think it's a challenge that many small jurisdictions, the Baltic states, but I guess also the Netherlands and kind of other smaller countries face. My sense is that these countries, like the law curriculum, tends to be more international and more comparative than kind of these broad traditional legal traditions like the German or the British. So kind of this need to be open to the world out there, to incorporate comparative perspectives is already, I think, an important part of the curriculum. You can correct me if I'm wrong, but of course it's essential to maintain and preserve the local identity and value. And now, your question, I didn't fully get it, was about whether AI systems are maybe less.
Forget AI, just courage and bravery of humans, if they're brave or not, and what is the value of educating brave young lawyers, just to make them really be courageous, be ready to protect themselves and others peoples. Otherwise, they just have a lot of knowledge, but they do not dare to speak out in real courts, etc. That's the following the mass.
No, I think I agree. I think there is a sense that kind of by kind of saying no, for example, I think students, at least in Germany, are to some extent encouraged to just look at the law. You're kind of an impartial applier of the law, so kind of try not to look at the broader ramifications of the case, like kind of try to not think about broader justice dimensions of a case, because you are not providing justice, you are applying the law. That is your task as a judge or a lawyer. And I think I think we need to become better in teaching civic responsibility, as I outlined. And I actually think it's important to. There is a risk. Lawyers are paid by clients. They serve their clients. They have a professional responsibility to do so. But there is clearly a risk that kind of these broader values that the law purports to convey, that they sometimes get lost. So I actually think we also need to place a stronger emphasis on civic responsibility in order to kind of provide lawyers with more courage, kind of this idea of these American movies where someone is kind of striving for justice, that I think this impulse still needs to have a place in legal education.
Now I understand your question more precisely. That reminded me of the United States a few decades ago, where they were very concerned about this question, and their response was to ensure that every law degree would institutionalize a course on professional ethics. That's as near as they got to having a requirement that you undertook an exam on professional ethics. Whether that's bravery or self-protection, I just don't know.
I would allow a brief comment on your remark as well. I would ask a question to this, whether it isn't it so that local lawyer who is also aware of criminal law, civil law, I don't know, perhaps even some parts of administrative law could give a better advice even on a local level, and if he or she even knows about something about European Union law and international law, or at least knows something about it, that could be more effective in the end. I think this is the question of Einheitsjurist on the one side versus the very so the scale of legal skills, which we have now in Estonia too.
Yeah.
And we have problems with this, but we are going to discuss this tomorrow.
Yeah. The question I asked of Andrej was a question for myself, really, because you're right, I teach in a very cosmopolitan law school. We have about 70 faculty. We will have representatives of at least 10 European countries on that faculty, and people from all, well, not Antarctica, but all continents of the world. And so we're no longer providing a legal education for England. We're now engaged in something much more different. And at times I do wonder that there are aspects of domestic law that we don't cover at all, and we actually do not have the expertise to deal with it these days.
So questions, 1, 2, 3. I ask you, there are 3 hands I saw. I would like to that you all 3 pose the questions, and then we probably have to close the list of questions. If someone wants to ask a question, please give a sign now. 1, 2, 3. Okay. So the 3 questions, and then we will proceed with answers.
Okay, quickly, I'm Tobias Locke. I'm going to speak later, so you'll get to know me anyway. 2 small points. I mean, one is that, what do you think about the fact that we are not only encountering a crisis of AI, perhaps in legal education, but also a crisis of reading more generally? That students, they don't, I mean, when Martin said we had to read all these cases every week, I mean, that wouldn't happen nowadays, in my experience. I mean, and the second is, what do you think is there anything distinct about law that distinguishes the challenges that come from AI in law from those that other similar disciplines like, say, English, history, or social sciences encounter?
Thank you.
So you need my question? Okay. Oh, sure. But so since it's a legal actually, let me introduce myself. My name is Mary. I'm an attorney in New York and DC. I also did my master's in European law in Pajuste, but I also use AI now. I'm an arbitrator. So since this is a legal education seminar conference, my question would be, in the US now we are increasing embedding in the system, the educational system for first years, the learning AI proficiency legal research, because those are very different skill sets, the traditional legal research and using AI tools. So I have two questions on those. First, how far do you think is European law schools to embedding those in their curriculum? And second, what do you think would be the biggest obstacles in adding a research through AI tools compared to traditional legal research that we currently have?
Thank you.
Good afternoon, Tabea Baumeister, University of Regensburg. Coming back to this problem that AI might give us better answer than first-year associates and the like. We've had the statement that therefore we should include AI in legal curricula, and I was wondering whether we maybe should do the exact opposite because of the problem of de-skilling. If we hand AI tools to first-year students, they'll never learn to, or they might never learn to think properly about these aspects. So I'd be really interested in your thoughts on that. And secondly, also facing this problem of first-year associates and AI maybe being better at tasks, don't we have a crisis in training, as an on-the-job training, because law firms might not be interested in hiring as many first-year associates as they used to do, and therefore there are not being enough legal professionals being trained on the job? Or is it actually part of the solution because we need less lawyers anyway?
So I saw there one more hand, or was it? So please, and then.
Hello, my name is Beatrice Munchinskaita, and I'm from Dublin City University. I'll be speaking tomorrow, so you'll get to know me tomorrow. I guess I have a kind of a different question, not a very practical one, but do you think, and this is towards both speakers, do you think there is an argument to be made that the law will always remain a human enterprise because AI simply lacks the soul and the heart that humans do? Or is that just kind of an anthropocentric exceptionalism view that is, you know, just rosy but not very practical? If AI eventually does the job better, we will become obsolete.
Thank you. So, a lot of questions.
Oh gosh, okay, going backwards. Yes, you're all going to be obsolete, you lawyers, but thank goodness I'm the age I am, so I don't have to worry about this any longer. It's a serious problem for young scholars and professionals. And I am really delighted I don't have to have several decades of professional practice in front of me, faced with this, the scale of these changes. And then a couple of the questions relate directly to reading. And this is a problem because, yeah, law requires intense, or has required traditionally, intensive reading of texts. And if you're not prepared to do that, you can't get under the skin of the subject. And I don't have any answers to this other than we law teachers create problems for ourselves if we give long lists of texts each week for the students to have to read, so that we're really providing an incentive for them to skim read or to use techniques to avoid having to read those texts. And what needs to be built into the curriculum is a sense that, okay, this week in this seminar, we are going to read one case or one text. And we're going to spend an hour dissecting that text. Never mind all the other cases or text relating to this topic. So they have no excuse but to read intensively and to be grilled intensively. And if we can't do it with long lists of cases, then take one case and say, this is an exercise in method of reading and interpreting and analyzing. So that's the only way I think we can try to stem this problem, which I accept is a real problem. I suppose the problems are identical to be us in the other arts subjects, except they don't have that professional dimension. After all, I'm sorry to say this, but students come to university to study English literature or history because they have a passion for English literature or history. I have not encountered a huge number of students who come in with a passion for law, except they want to be players in a game. And maybe what the future game is, the economists would say, you know, you're redundant anyway. The world's run by these market systems. And if you really want to get on in the world, it's not law any longer. It's econometrics. That's how the world's run. And I'm bowing out of the European law school's questions. After Brexit, we're no longer a European law school.
I think I probably won't be able to answer all questions. So maybe a few brackets. So maybe the first one is also on reading cases. I think there I agree with Martin's suggestion that it's like on the one hand, large language models, they are there and students are going to use them. I think we won't get around it. And they are really good, I think, at detecting the essence of texts. So in some sense, if I have 200 pages to read and for 4 different classes, it's a rational choice for students to put it into AI and say, just extract the kind of the essence of the text. And I think that's also a useful tool in some sense. Like there's no reason not like to say to students, you shouldn't do so. But it's also clear something gets lost if you don't read a case. So I think there needs to be a format in law school where you with students you closely read a legal decision and you kind of really analyze it and kind of go beyond what large language models are capable of doing. So I think that was also kind of a question that surfaced around before. I think this, I don't know if this is really a brand, but this Oxford model where you have one lecturer, one instructor, and you have a small group of students, and then you kind of, for example, that could be, I think, a format that becomes more important where you really closely read a text. I think that should have played a more prominent role in legal education anyway, and I think there's a strong case that it's even becoming more important. Is there something distinctive about the law with regard to generative AI? I think probably not singularly, but I do think that it's clear there are a lot of features in legal practice, in legal craft, that display similarities to how large language models work, right? Like these analogies, the kind of working. So I think it's probably distinctive with regard to language sciences. I think there's a similarity, and that clearly makes legal work to a significant extent replaceable by large language models. So I think that's, in that sense, law is not entirely distinctive, but within language sciences, I think there is something where I think LLMs are particularly well in emulating legal argument and legal structures. Then kind of the argument about how we should use AI in legal education. Is it better trying to abandon it entirely, to teach students critical thinking, analytical rigor, and so on, or kind of, so what should we do about it? I think, for example, the decision by LSE kind of to abandon seminar papers or to a significant and say we kind of revert back to the old school law school exam where you don't have the help of a computer. I think that's a reasonable decision. I think in examinations, oral exams, written exams, I think they will play a more important role. I think we can't kind of, if we just give students a paper and ask kind of a topic and ask them to write a paper, or kind of we have these solving legal cases at home over a period of several weeks, it's unrealistic to expect students kind of not to use LLMs. But I do think what, for example, could be one approach is to, for example, to encourage students to use AI, but then to kind of to have an element of reflection where they said, yes, you're using it, but I want you to tell me exactly how you used it, which prompts you used, and which efforts you took to improve the output of AI, to critically reflect upon what you thought was done well and what wasn't. So basically with the use of AI to reach a better product by AI output and human critical or student critical reflection. I think that could be one, but it's difficult to implement. It's for teachers. It's difficult to review. But I think this could be one format that I think would be helpful. And then maybe something about the last point about the law as a human enterprise. I think there's clearly. I don't think that's. I think there's a strong case for this when we talk about taking the responsibility for a decision, showing the political judgment, the sense for justice that legal judgment requires. That is something I don't foresee large language models to do. When I think about constitutional judges sitting on a constitutional court and deciding hard cases, there are so many broader ramifications. There's kind of such a responsibility for the public interest and for the political community. That is not something that AI can replicate ever. I would think so. I think there is a human element in legal practice. There I fully agree.
So thank you very much. I think the speakers have deserved an applause and a little thank you from the university.
It's very kind.